delighted to be here. I was here about a year and a half ago when this case in Bangkok was really just starting. It's a case involving a media rights activist named Klangnarong, and he had been sued by a company called Shin Corp. And before I start talking about the case, though, I do want to answer, or at least start to answer Doreen's question, which is why is a lawyer from New York standing here in Hong Kong talking about a case from Thailand? And why do you care? What possible relevance does it have to anyone sitting in this class? Well, I guess there's two answers. One is a traditional answer. I represent large international media companies, BBC, we do work for Reuters, you heard I do work for Singtao. Many of the larger media companies obviously have reporters, they have offices all around the world, whether it's Indonesia, Bangkok, Hong Kong, and are subject to those laws. But the world's changed in the last couple of years, and it's no longer just big media companies that find themselves being brought into foreign jurisdictions. And the answer to why that is really is two words: the internet. All of you sitting here tonight, you may sit in your office, you may write local news, you may work for a local paper, and then you put it on the internet. And that desire to reach as many people as possible with your news and information has really had repercussions in the last couple of years. Courts now around the world are starting to find that when you go on the internet, you can subject yourself to jurisdiction, to lawsuits, to the laws of countries all over the world. And just to give you an example, there was a case in 2002 in Australia called Gutnick versus Dow Jones. It involved an article in Barron's, which is a U.S. publication. About 500,000 copies of Barron's are printed every day, hard copies, distributed about 99% in the U.S. They're also online, and about 300,000 copies are distributed online to subscribers, and about 1,700 of those were subscribers in Victoria, Australia. And this was a case in which the subject of the article was a businessman. There were charges, allegations that he was involved with money laundering, tax evasion. And he sued in Australia. Dow Jones said, wait a second, our servers in the U.S., we're in the U.S., we publish in the U.S., and the court said no. He said, where you publish, for purposes of at least British common law, is where people read your material and where people have reputations that can be harmed. And based on that, Dow Jones found itself defending a case in Australia. We see this more and more often, time and time again. Publications in one country are finding themselves being sued all over the world. So it's more than, I think, an academic interest in the laws of other countries. It affects you. With that, I want to talk a little bit about criminal libel, and particularly about this case, Shin Corp. Shin Corp is, I guess in America, there would be Verizon. It's the largest telecommunications company in Thailand. They have a near monopoly on phone service, on internet, satellite communications, and have the largest TV station in Thailand. They do business with the government of Thailand because all of those broadcast frequencies are considered to be national resources. And so they have to get a concession from the government. They pay the government fees, and in return, the government of Thailand grants them a right to run internet, satellite, telephone, and they receive revenues and profits from that. Shin Corp was founded by Thaksin Shinawatra, who, until I guess very recently, was the Prime Minister of Thailand. It was founded by him in the 80s before he became Prime Minister. And when he became Prime Minister, there was a bit of a tussle back and forth in terms of whether he could hold on to any interest in Shin Corp. He eventually divested himself of shares in the company, gave up his positions, And the shares that he divested himself of went to his daughter, his son, brother-in-law. And in terms of just the facts of Shin Corp's profits, after Thaksin in 2001 became prime minister and his Thai party came into power, Shin Corp's profits started to increase dramatically over the next couple of years. Part of that was surely due to business acumen, but there were changes in government policy that were proposed by the finance minister, approved by the prime minister, and in the course of 2 years, Shin Corp's profits increased threefold. Because of these changes in policies, even the shares of Shin Corp had a name among investors, Han Thaksin, Thaksin shares. It was perceived in the market that because of the corporation's ties with the government, it was a good investment. And indeed, their stock price went up 5 times. Those are the facts. Enter Supinya Klangnarong. In 2003, Supinya is a media rights activist. She is the head of something called the Campaign for Popular Media Reform. And their mission is to broaden media ownership in Thailand, to get away from this sort of duopoly or monopoly of media ownership in the country. Supinya wrote a paper in July of 2003 in which she set forth these facts, and she expressed her view and opinion that Shin Corp's dramatic rise in profits was largely due to government policy. She was interviewed in July of 2003 by a newspaper called The Thai Post. And in that interview, and I'll read you a little, again, she talks about the facts, and this is what she says. This kind of business works with concessions, she's talking about Shin Corp, which means it deals with political power. She also stated that for the 5 years that the Thai party is in power, it's helped the companies in Shin Corp gain more profit and cement the business and political sectors into one. Shin Corp's income will turn out to be the necessary capital that strengthens the Thai party. These things will then become like a family business. In addition, people from politics, business, and social welfare are all relatives. Now, at least in my country, that wouldn't be very big stuff. What she was essentially saying is, you know, this looks like a conflict of interest to me. It bothers me that there are people in the government who are related to this major company that's being regulated by the government. She ended up being sued a couple months later by Shin Corp for criminal libel. And Thailand is one of many countries that still enforces its criminal libel statutes and allows private parties to bring suits under the criminal libel statute. Under Thailand's criminal libel provisions, if you are convicted, you are liable to up to 2 years imprisonment as well as a fine. In addition, Shin Corp brought a civil libel suit against Supinya, seeking an astronomical sum of money, particularly in Thailand. The equivalent, I think it was 40 billion bahts, the equivalent of 10 million US dollars in a country where the median income is a couple $1,000s. And the gist of 400 million bahts. And the gist of the claim was that Supinya was inferring that Shin Corp, its profits were due based on government connections rather than business acumen. That was the lawsuit. And the suit implicated, I think, 2 important issues that you see time and time again, particularly in Southeast Asia. One was the issue of fair comment. Subpoena statements weren't provably true or false. She was expressing her opinion about the facts, as everyone knew, which is, what's the reason for this increase in profits? Is it a good thing? Is it a bad thing? And fair comment, the right to criticize and express opinions, is a cornerstone of free speech recognized under international law as well as in democratic societies. In coming here, took a quick look at a recent Hong Kong precedent. And this is at least what the Hong Kong Court of Final Appeals had to say a couple of years ago about fair comment. The right of fair comment is the most important element of freedom of speech. The court should adopt a generous approach so that the right of fair comment on matters of public interest are maintained in its full vigor. And the whole purpose of fair comment, it protects the speaker, but ultimately the protection and the purpose is for the listener, is for the public. And the whole premise is that in order to be informed and to make intelligent decisions in terms of self-government, more information is better. The other issue, of course, in Subpoena's case was the issue of criminal libel. This wasn't a civil libel suit, and she found herself facing prison. And criminal libel is pretty much a holdover from colonial societies, from seditious libel statutes, breach of peace statutes from the 19th and the 18th century. And it has little place, if any, in modern society. There is a remedy for damage to reputation. It's a civil lawsuit. And that is a principle that increasingly in the last 5 years has been recognized by international bodies. There is a growing body of international law under something called Article 19 of the UN's International Covenant for Civil and Political Rights. And the body charged with enforcing that is the UN Human Rights Committee. And they have now said several times in the last couple of years that countries should abolish criminal libel statutes. That is the position taken by the UN Special Rapporteur on Freedom of Opinion, the Inter-American Commission on Human Rights, the Organization of African States, and the European Court of Human Rights. And indeed, in the last couple of years, a number of countries have abolished their criminal libel statutes. Ghana, Sri Lanka, former Soviet republics. And where it exists, largely, it's fallen into disuse. There's still criminal libel statutes on the books in Hong Kong, in Japan, South Korea, my own country, the United States, England, Europe. But they have really not been enforced for the last 50 years. And I don't think that in most countries there's much of a prospect that they will be. Southeast Asia does present a little bit of a different picture, and it's a little bit of a mixed bag. Ying Chan reminded me that this is the 10th anniversary of the decision in Taiwan. And I'll just briefly tell you, before your dean was the dean of the School of Journalism, she was a reporter in the United States for the Daily News. She was on a fellowship at Harvard, and she had co-written an article for Asia Weekly, a Hong Kong-based newspaper, speaking of what happens in Hong Kong can find its way into other jurisdictions. The article was about fundraising, offshore fundraising during the 1996 presidential election in the United States, and particularly this was the Clinton re-election campaign. There was a White House official, a man named Mark Middleton, who had taken a leave of absence so that he could fundraise. Nothing wrong with that. He went to Taiwan, and according to a source who was at a meeting, a offer of a $15 million campaign contribution was made by a man named Liu Tai-ying, who was the head of the, I guess, the business head of the ruling KMT party. No allegation that any money changed hands, but nonetheless, newsworthy information, and it was reported. A criminal libel suit resulted from that, in which Ying and her co-author in Taiwan were named as defendants. I can remember this because there were long discussions about whether Ying and the United States should go to Taiwan to defend a criminal libel suit. And of course, the prudent lawyer's advice would be, no, you're crazy. And of course, she went. And I think she went to make an important point. And when she went, she did not go alone. She went with an incredible amount of amicus support from international news organizations from around the world. And the argument was that Taiwan had a constitution, like many countries, with wonderful glowing language about freedom of the press. Not used very much, but there. And there was a defense, what's called a good intent defense, that if statements were made with good intent, that you should not be held liable for criminal libel. And we made the argument that Taiwan should adopt a fault standard, much like the fault standard in the United States, that when reporters are engaged in responsible good faith journalism, and they have no reason to believe or know falsity of a statement, and they're reporting on matters of public interest or public officials, they shouldn't be held liable. And in a decision of first impression, that's exactly what the court in the Ying Chan case held 10 years ago, and was a landmark in Taiwan. It was, I think, the first case to really recognize protection for the press under Taiwan's constitution. It ended up being affirmed by, I guess, the highest court, and even became precedent for a similar fault standard in civil libel cases. And the result of all that was that there's much less criminal defamation cases, activity in Taiwan than there were 10 years ago. The magazine was convicted and sentenced to 1 year in jail for alleged errors in reporting on a suspicious fire. The case was eventually overturned by the Indonesian Supreme Court, but criminal libel proceedings and convictions still continue in Indonesia. Cambodia, there's been, by my count, about 9 criminal libel prosecutions in the last year, including one in which the opposition leader in Cambodia was convicted for defaming Prime Minister Hun Sen. Eventually received a royal pardon, but criminal libel still remains alive and well in Cambodia. East Timor is another example where the Parliament recently enacted a law making it an offense punishable by 3 years in jail to defame a public official. And then there's Thailand. Given that sort of neighborhood, what happens in each one of these cases is very important because it really can affect what happens in other countries. In Sapinya's case in Thailand, there was an incredible amount of international support by non-government organizations from around the world. The Southeast Asia Press Alliance in Thailand, the Asian Human Rights Committee right here in Hong Kong, the International Federation of Journalists in Australia, the Committee to Protect Journalists in New York, Article 19 in London. And what they did was an important part of, I think, the defense of this case, which is to keep it in the public eye, and frankly to let the court know that the world was watching this case. And the reality is, for every one of these cases like Sapinya, there are 10 cases where they go right under the radar screen. It really did have an effect. Among other things, there was an international observer, Mark Stevens from the Law Society in England, who went to observe the trial. He introduced himself to the court, to the counsel, and sat there every day. So the court knew that this case was being watched by a lot of people. And then there were the lawyers, and lawyers from Canada, Bangkok, London, all contributed pro bono legal services, fancy Latin for free, to assist Supinya and her lawyers in Bangkok to craft defenses, because ultimately cases are won or lost in courtrooms. And I think that also played an important role in this case. One of the things we pointed out to the court were some of the international standards, decisions by the UN Human Rights Committee that I talked about a little bit. And we asked the court to construe their own law, their own domestic law, in conformity with these international standards. And indeed, Thailand has a great constitution on paper from 1997. It has a defense in its penal code for fair comment. And the question was the court going to give meaning to this fair comment defense in connection with statements that were harshly critical of the Prime Minister and this major corporation? And the irony, of course, is that's precisely when fair comment is most important, is discussion of public figures and public issues. The case went on and on and on. 20 days of testimony spread out over many, many months. And I will tell you, it really took a toll. I should also tell you that Supinya was not the only defendant. Also sued were the editor, the owner of the Thai Post, which was the only paper that had reported her comments in Thailand. At the end of all that testimony, Shin Corp offered to settle. They offered to withdraw the criminal charges, the $10 million civil libel case, and all Supinya had to do was apologize. All she had to do was give a public apology. And she said no. And I have to tell you, that's one of the moments when a lawyer's heart goes in their mouth, but it was a principled stand. On March 15th, the Ides of March, the court ruled. And it acquitted Supinya, it acquitted the Thai Post, it acquitted all the defendants. And the court essentially found that Supinya's criticisms did constitute fair comment. And it essentially made a couple findings that I think were important, not only in this particular country, but for other countries in the region. It found, one, that the facts on which Supinya was expressing her opinion were accurately stated. So the facts I started out telling everyone tonight, that the profits of Shin Corp dramatically increased after Thaksin took power. And it essentially said that you're entitled to express your opinion on why that might be. It looked at the plaintiffs, and I think in an incredibly important part of the verdict, it found that Thaksin, as the Prime Minister, is a public figure and is subject to legitimate criticism. It found that Shin Corp, as a public company, is subject to criticism. It found that Supinya, as an activist, had a legitimate interest in expressing her views and opinions on the Prime Minister and on this company. I will say it's the one part of the opinion that gives me a little pause, only because the right of fair comment is not limited to just activists. It includes the press and every member of the public. And last, and I think most heartening, it found that the Thai Post, as a member of the press, had a legitimate interest in reporting Supinya's comments. So, great decision for Sapinia, great decision for the Thai Post. What does it mean? Where do you go with that? It is, I think, and I will grant you my crystal ball is a little foggy, that is it going to end criminal libel in Thailand? Probably not. Is it going to make it more difficult for the next potential plaintiff in one of these suits? I would hope so. Thailand still, like many countries, has insult laws on the books. It is punishable by up to 3 years in jail for insulting the king, and I'm not suggesting that anyone insult the good king of Thailand. But it is still a culture in which the notion of criticizing authority figures is something that they're going to take a little while to iron out. I think that there are a couple things that happened in this case, that happened in the Ying Chan case, that really are the kinds of things that can help with legal climate, not only in these cases, but in cases down the road. And I started jotting down some notes. One is close the door, beat the dog. What do I mean by that? I think that it really did make a difference in this case that there was so much public attention. And it's not an easy thing, because you surely do not want to have this sort of cultural imperialism where you are telling a court that somehow they need to do it this way. Ultimately, courts are going to rule on their own domestic law. But there are minimum standards in international law. And I don't think it's a Western or an Asian or a European question. I think those minimum standards apply throughout the world. So I have to say that the kind of intense exposure was a good thing. The role of international law. I think that this is another good example in which I think that international law does play a part in bringing countries along in terms of development of their own domestic law. I wrote something else down. There goes the neighborhood. And I would tell you that perhaps the most important outcome I would hope of this decision is its effect on other countries in the region. Courts are not oblivious to what happens in a neighboring country. And the decision in Sapinia may have some effect on whether it's abolition of criminal libel statutes or articulation of protections for the press in criminal libel cases in other countries. I read recently that the Prime Minister of Cambodia has now come out in favor of abolishing Cambodia's criminal libel statute. Does that have anything to do with the decision in Sapinia? I don't know. But is it changing a legal climate? I do hope so. The next thing I have written down is don't kill all the lawyers. The fact of the matter is that ultimately these cases are won or lost in a court of law. And my own view is that ultimately what will help change legal climates in other countries is training lawyers to understand and to argue persuasively protections for the press. And the last thing that I have written down here is that good journalism makes good law. Ying Chan's case is a great example of that. It was good, solid journalism. And it helped with securing a wonderful result in Taiwan. The same thing with Sapinia. It was a classic example of opinion based on accurate facts. So that's where we are. I'm going to stop jawboning and open it up for any questions, comments, discussion that anyone would like.
I was just wondering if the recent protests in Thailand had any effect, any bearings on the outcome of the case.
I wonder. I don't know. There is always a question and an issue of transparency and independence. I would like to think that courts are not swayed by events that go on outside the courtroom. I don't know that. And so I don't really have an easy answer for you. If Thaksin was not sort of on the political ropes in terms of his own power, Shin Corp was recently sold. If those events hadn't happened, could there have been a different decision? I don't know. The answer is there could have been. I do think that may have played into it, possibly. From my own way of thinking, I would hope it didn't. I mean, ultimately, the outcomes in these cases should be based on neutral principles of law, fairly and transparently applied. But in answer to your question, it is possible that those events might have had an effect on the decision.
Robert, you talked about this idea of the good that comes from having an international bar, international defense team that goes out there. Two questions. One, is there ever a situation, and how do you evaluate this, of where this can backfire? Where having Mark Stevens present in the courtroom actually would do more harm than good? And the second question is, assuming that there are cases where it can be beneficial, and obviously this demonstrates that there is, how do you build up a more permanent team of roving legal defense lawyers who can help out in situations like this?
In answer to your first question, boy, that is always an issue, and that's always the debate. The court in Thailand, for example, the Subinya's legal team had, I think, 4 or 5 witnesses who were slated to talk about law in other countries, and the court didn't want to hear it, and I understand that. There's a debate that came out of a recent U.S. Supreme Court case involving cruel and unusual punishment in terms of the death sentence for minors. One of the Supreme Court justices cited case law from other jurisdictions to show that in the civilized world, other countries do not execute minors. He was pilloried by the dissent. He was pilloried in the press. And so it is always a very tricky and delicate issue about how do you bring to a court's attention international legal principles without seeming like you are engaging in cultural imperialism. And I will say, for example, in Ying's case, one of the things we were very cognizant to do was to cite cases, other cases from the region, from Japan, from Australia, from South Africa. I'm not sure we might have cited one Supreme Court case, New York Times v. Sullivan, possibly in a footnote. But it was very important that it be presented to the court that this was the decision we were urging was something consistent with other countries in the region. So in answer to your question, it's a really important issue. Another issue is, do you ask courts to just not enforce their criminal libel statutes? But the reality is courts don't do that. Legislators can abolish a criminal libel statute. And as much as it is the position of many of these NGOs that criminal libel statutes shouldn't exist at all, ultimately what you do in these cases is you ask the court to find increased protection for the press from criminal libel, particularly when statements relate to public officials, matters of public concern. In answer to your second question, Doreen, about training, it's critical. Ultimately, I find myself involved in these cases because I love it. I mean, I had a sabbatical last summer, and I found myself flying off to Bangkok to help out with the criminal libel case because I thought that was fun. I don't think most people have that view of a vacation, and quite frankly, I keep a very low profile in these cases, precisely because it's not me. The people that should be front and center making these arguments on behalf of the press are the lawyers in that jurisdiction, whether it's Taiwan or Bangkok or Singapore or anywhere else. And ultimately, there is something called the media bar, and it is a function, quite frankly, of money. It's a function of the fact that large media companies have flourished in jurisdictions like the United States and England. And so there are now a cadre of attorneys like me who know a lot about media law and who represent media companies all over the world. There is starting to be large media companies, not starting, there are, in other parts of the world as well. Hong Kong is a great example. And what I do think is necessary is starting to train, starting to create lawyers who understand media law, who understand libel principles, the things that whether you're working journalists or journalism students, you deal with day in and day out. You may not realize it, but the fact is you've got questions of privacy, copyright, libel, and where I come from, the phone rings 7 or 8 or 10 times a day, and someone's calling me up with a question. The journalist is calling me up and saying, can I wear this wire? Can I write this? Would you look at this? Would you vet this? Is this a copyright infringement? And there's a real partnership between lawyers and journalists. And that ultimately is what I think is kind of a way forward in parts of the world that are looking to promote the rule of law in a sort of neutral fashion, is to create a lawyer class. And I suppose, you ask a carpenter, they'll tell you to hit a nail. You ask a lawyer, they'll tell you to make more lawyers. But the reality is that ultimately journalists can't do it on their own. You can write all the op-ed pieces that you want. Eventually someone has to go into court and argue on your behalf. And so I guess the answer to your question, Doreen, is it's not enough for Rob Balin or some other attorney to come in from some other country to fly in one day and fly out the next. Ultimately, you need an indigenous crop of attorneys who are going to be representing and arguing on behalf of the press.
Rob, there's Singapore, Malaysia, to a certain extent, Hong Kong. There's criminal libel on the one hand, and there's also a very effective use of civil libel in Singapore and in Malaysia, as well as ownership issues. I mean, they pretty effectively tied everybody in knots in both those countries. And in Hong Kong, there's an issue of civil libel, and I know this from working in the newsroom here. In all these places, and it happens also to a certain extent in Thailand, and it's beginning to happen in Indonesia. You do get tied in knots in reporting on certain individuals in those countries. And Singapore has been so effective at it that using civil libel penalties, they've chased the international press away from writing about the Lee family. They just won't touch it for the most part.
You're right.
I mean, most journalists living in Singapore, and I know very good journalists living in Singapore, who simply won't write about Singapore. They effectively know not to do it. You don't screw around with the Lees or their friends, or you're going to end up in court, and you're going to end up spending the kind of money that the IHT, the Old Far Eastern Economic Review, and the Dow Jones and others have spent Asia Week and others who were hauled into court. And one of the lessons that I learned working in a newsroom in Hong Kong in management was that there are certain individuals in Hong Kong that you must be very, very careful about mentioning in print, and very careful about writing about. And it is an unwritten law that there are certain people who will drag you into court if you're not extremely careful. And that also has what's the word we were talking about? A chilling effect.
Chilling effect. An overused term, but nonetheless,
it
yes.
has a chilling effect. I mean, we never said to our reporters at the Standard, okay, you can't write about Mr. X. But we did have, I'll put it this way, I think we had a higher standard of proof before we went into writing about a number of individuals in Hong Kong, and not just the one man that everybody knows that you don't write nasty things about, but there's a whole range of people. And so this is the other thing, as an editor, that just ties you in knots, is what to do about this whole issue of harassment by civil lawsuit as well.
And you know, I don't want to sound Pollyannish, because the reality is that those kinds of discussions and decisions are made throughout the world, newsrooms in the United States as well, which is, you know, I don't know, Frank Sinatra, it's Wayne Newton, it's someone who is really known to be litigious, or was known to be litigious. And are you going to run with the story? And if you're going to run with the story, are you going to kind of have some heightened burden that, damn it, we better make sure we have the facts right here before we go with it? I mean, I think that's an issue that, you know, is an issue for newsrooms around the world. I think the difference in some countries, in comparison to, say, the U.S., is that there is a fault standard and a fault requirement in the U.S. And therefore, if you really are, you believe you're dealing with a public official or you're dealing with a public figure, the requirement that they show actual malice, that what you knew, what you wrote was false, or you acted entertaining serious doubts as to the truth, has pretty much ended libel suits by public officials in our country. They happen once in a while, but not a lot. And it's a strange thing, to me at least as an American lawyer, that the people that should most be written about, public officials, are precisely the people that the press is most skittish about writing about. I don't have an answer. I mean, the reality is that until and unless legal principles change, you're living with the reality of whatever jurisdiction you are in. And I also know that journalists do many things to get the information out, to write their story. There's creative vetting, there's creative editing. You know, if facts and information are really important and they are really in the public interest, they usually have a way of getting out in a lot of jurisdictions. I do agree. I don't know if you made the comment or you did, that it is a shame that sort of Dow Jones and the Times sort of took a pass on Singapore. I think they had just, you know, spent enough in legal fees and required apologies. The point you make is precisely why ultimately the ability to engage in sort of reporting that provides the public with information about the things that are most important, the policies of government, what public officials are doing, not their sex lives, but what are the policies, what matters, what we call political speech. Ultimately, the ability to report on that, if you're in a jurisdiction where you're going to find yourself in trouble for reporting critically on public officials, requires change in law. There really is no other way around it. And again, that change in law comes about from lawyers, from journalists engaged in nice, measured, prudent speech about the need to change the law. You know, I don't have much more of an answer about, you know, why is it I can't report what I want to in a jurisdiction, other than to say that obviously, you know, newspapers, magazines, TV stations are businesses too, and they make profit-loss decisions about, is it worth it to us to find ourselves dragged into court in a civil libel suit and to pay umpteen dollars in barrister's fees, as well as having to pay the plaintiff's fees, as well as to have to pay damages to write this story.
And that's precisely what happened in the Albert Chang case, which of course greatly expanded the fair comment defense. Albert Chang personally Balin was able to put the attorney's fees, because he happened to be independently wealthy and could pursue the case beyond the Court of Appeals, take it to